Good evening. Welcome to the webinar. This is Jacqui Brauman here from TBA Law. It's evening. I'm in my office at home after hours in my workout kit because that's life. Tonight our webinar is on horror stories. It is October after all, so I wanted to do something along the lines of Halloween. So horror stories in relation to claims against estates. So I'm going to share my screen shortly so you can see the slides. And we'll go through, and I'm going to go through a few case studies about claims against estates. So, this is one of my dogs. This is Scout. So claims against estates in Victoria, the law changed around this area in 2015. So it used to be open slather on wills in Victoria. Now they've got certain categories of people who can make claims against an estate. So it's now ruled out essentially grandchildren and neighbours, carers, unless someone is financially dependent, and they have to prove that, and they have to prove a number of other things to be able to establish that they should have been provided for. Now, a lot of people say, well, why even make a will? Because the majority of wills are respected, all right? 90 to 95% of wills aren't claimed against. And we're lucky in Australia to have testamentary freedom to even make a will, to say whatever we want to say anyway. Many countries don't allow testamentary freedom, or they only have partial testamentary freedom, and then the government will actually say what percentages need to be given to whom. So given that we've got testamentary freedom, the law developed around that. Oi, get out. There were needy people in society that morally society determined that the person who's passing away should take care of. So you do have a moral obligation to certain people in your lives. And primarily this area arose because husbands weren't leaving things to their wives, and their wives were left destitute, or they weren't providing for certain children. So those are now the categories, the main categories of people who can make claims against estates. They are spouses, children, and people who are financially dependent. Now, within the category of children includes stepchildren as well. So those are the three categories that I'm going to cover off tonight. Now, when I'm in the slides, I can't see you making comments. So if you have comments or questions, put them in the chat, and I'll come back to that at the end and answer any questions. Sharing my screen. So as I said, tonight's topic is claims against estates. Some of the horror stories. Now, all these cases have been in the last 5 years or so, all in the Supreme Court, either in Victoria, South Australia, or I believe there's one from Queensland. So again, who am I? Jacqui Brauman is my name. I've been in business for a bit over 7 years. TBA Law is the business. You've met one of my dogs down the bottom corner there. You can see my husband and one of my other dogs on our boat out on Eildon. We do a lot of fishing on weekends. It's a really good outlet, I find, because I unplug. It's meditative, and I'm competitive. And the other little logo on the other side of my lovely headshot there is the fact that I've earned an accredited specialist accreditation in the area of wills and estates. So did my law degree, was a lawyer for quite a few years. Then I did my master's degree in applied law in wills and estates. So the master's degree took another 3 or 4 years. And then I did a full year accreditation program with the Law Institute of Victoria in this area. There's only about 80 of us in Victoria out of about 12,000 lawyers. And you've got me. So when you study wills and estates, you also study all the aspects of deceased estates and claims against estates. But I'd prefer not to do litigation. So these claims tonight are things that I try to prevent through estate planning. So that is where my particular focus is. Estate planning is not just wills. The poker chip there on the screen shows so many elements to estate planning. Wills are one of them there. You've got enduring powers of attorney. You've got binding superannuation nominations. You've got trusts. You've got life interests. You've got family trust appointments. All sorts of things need to be considered. And you can do smart estate planning that would prevent a lot of claims too, if you're really concerned. So just bearing that in mind, as we're now going to work through a few of these case studies. So, claims against estates by spouses. One of the very first claims against an estate that I worked on was a girlfriend of an elderly fellow. They'd been in a relationship for 7 or 8 years. Lived separately. His family considered her to be a carer only, and that there wasn't a relationship. Now, it was a little bit difficult because he had kept her a little bit secret. If you can hear that squeaking, it's my other dog with a squeaky toy. They just want my attention all the time, just like children, guys. So we acted for this woman to get something out of the estate because he hadn't redone his will since meeting her. The will was about 20 years old. So realistically, he'd failed in his duty to take care of her. He hadn't considered her, hadn't redone the will. Everything went to his children. So she made a claim so that she could have somewhere to live, basically. So that was the first instance that I came across where a spouse was making a claim against an estate. Now, I don't consider that a horror story because it's almost exactly why these laws were made in the first place. A couple of recent cases, neither of these are mine. These are just cases, like I said, that have been through the Supreme Court. This one, a Victorian case in 2017. So an elderly man passed away. He had no will. So he's what's called intestate when you have no will. So a claim can be made against an estate whether there's a will or not. So he also had no children. So the next people in line to inherit, he was very elderly, he didn't have parents, were his brothers and sisters who were also dead, so it was his nephews and nieces who were lined up. Now, he had been in a relationship for 25 years with an old lady who was now 85. Because he didn't have close family, no one knew about her. They lived separately mainly, but it was a 25-year relationship. They had associated together. People knew of the relationship. A nephew came forward and tried to get the management of the estate so he could control it and break it up between him and his cousins. But the court found that there was enough evidence to find that this elderly 85-year-old woman had been in a relationship with the deceased for 25 years, and so granted the administration of the intestate estate to that woman. So that was a big step because to recognise a spouse essentially gives the entire estate to the spouse. Sorry. Technical hiccup. The other spouse case study I've got is a similar case study to the ones that I've talked about. So a relationship that's kept relatively secret from the family. This one again was 2017. It was in South Australia. So the woman commenced a relationship with the deceased man in about 2014. So it was the fellow who's passed away. So she moved in some clothes and some art and some stuff around the house, and she still had lots of stuff in her family home. So she didn't fully move in. She had a key to his house. They socialized together. They discussed marriage. She claimed they were engaged, but there was no announcement and no party. They called each other partner, but they never told Centrelink of the relationship. Not that that's indicative, because a lot of people hide that from Centrelink, don't they? However, it can be detrimental. The court found that while they had discussed marriage and they'd been together for 3 or 4 years, the relationship wasn't a fully committed one. That's what the court found in this case. And so the woman's claim that she was a spouse was not successful. So there you go, some spouse claim stories. Spouse claims are often very common in farming cases as well, because a large farming property will probably be multi-million dollars worth of land and very little other assets other than the assets used to farm, or the equipment and the stock. So quite often, in past generations particularly, the farmer has left the whole land and farm to the son or sons. So the wife and the daughters miss out. More importantly is the wife, because if the house is on the farm, then she's left without any certainty about where she can live. She might have a bit of money in the bank, but essentially she's destitute and reliant on her children, which may not necessarily be favourable to her. So the laws around that developed such that a husband should leave a wife a house and a nest egg. So that's sort of the standard that has been set if the estate is large enough. Getting on to children. So this is a particularly difficult issue when you're dealing with adult children. Minors, you can understand that a parent should still be looking after the child. But with adult children, a lot of people argue, well, your obligation to your children subsides and they're out on their own and they should look after themselves. So yes and no. So I'll go through some of these scenarios. So the first two cases are estranged children. So quite a lot of people, when they're preparing their wills, are worried about a child that they haven't seen for 10 or 20 years and they want to leave that child out, and whether that person will make a claim or not. That's the typical concern that people have. So here's two scenarios that have gone either way. So the first, both these cases, in fact, are in 2014 in Victoria. So the first case is where an estate was worth about $650,000. So the old man survived his partner, so he was the last one left, and he had 4 children. He had 2 children to his first marriage and 2 children to his second marriage. He left his entire estate, the whole 650, to the youngest child in the second marriage. So he obviously had 3 adult children that he didn't provide for at all, and all of them, in fact, were in financial need. So none of them were doing very well. So they hadn't gone out and stood on their own 2 feet, so to speak. However, they hadn't been financially dependent on him. They were estranged. The court didn't go really deep into the poor nature of the relationship. The court certainly looked at the behaviour of the deceased during his life and found that the old man had been very violent and prone to cruelty, and that in fact all his children were quite traumatised. And the court also found that the old man had failed in his parental duties towards his children. And so the whole $650,000 was split equally 4 ways. So quite an interesting one. The other case was almost the complete opposite. So again, 2014, and again, another very small estate. This estate's only 200,000. This was a woman who passed away. So the old lady is the last one left, and she had 5 children. So she was estranged from 3 of the 5 children. She'd left 3 of them a very small amount, just a token amount really. One of the children got 40,000, and the balance, so the last 160,000 or so, all went to one particular daughter. So the latest will was done in 2009. So this is it was only a year before she died. So it actually took 4 years for this matter to be ongoing to finally get to the court. So there's a horror story for you, dragging on over $200,000. So 3 of the children made a claim. The court found that 2 of the children had isolated themselves without cause, that they had isolated themselves more to do with the relationship with their sister, which is the person who got the entire estate. And so the court found there was no fault of the mother as to why the relationship had broken down. So the court actually awarded those 2 nothing. So 2 adult children claimants got nothing. The third claimant, the court looked at that relationship and found that relationship had ended more because of the fault of the deceased and not the child. So the child wasn't so much to blame. However, that child only got an extra $19,000 on top of their tiny little legacy, which I think was $1,000. So one of the claimants got $20,000 out of their effort. And then the original legacy of $40,000 for one of them stood, and then the daughter got the rest, and 2 got nothing. So a very interesting one for estranged children. He's really going to town with that squeaky. The last one that I wanted to look at was for an estate where there was a mentally ill child. So this case, it was another Victorian one. It's about the oldest one that I've looked at. So it was 2013. So the deceased, an old lady, left her entire estate on trust to be held by the executors for her son. So it was $450,000 she had approximately. Her son was a paranoid schizophrenic and couldn't live independently. So it wasn't a bad idea for her to leave it in trust. And she did provide for him, her entire estate, to her only son, who was mentally ill, and they probably didn't have a great relationship. But interestingly, the court found, somehow someone representing the son made a claim against the estate, and it was probably, no, it's a personal name. I was going to say the state trustees, but it's not. So someone helped the son. So the court found that it wasn't appropriate for those funds to be held in trust by the aunt and the cousin, who were the executors of the deceased estate. So the court was satisfied that they should be in trust, but wanted someone independent to manage the funds because they didn't think it was appropriate who the deceased had chosen. So a really interesting aspect of a claim against an estate. So the claim was actually brought by the son because he wanted to control his money himself. But instead the court didn't give him control, but the court took the control off the people who had the control. And in fact, the court bought a property in the name of the son for the son to live in, but put a caveat on the property. So the court put a caveat on so the son couldn't sell the property without the court's permission, and then all the balance of the funds were put in court funds. So the court was going to manage the funds for him on trust. So fascinating little twist. So no one got what they wanted, essentially. Hold on 2 seconds. So you might have noticed the dog stopped the squeaky toy. It's because he grabbed my foam roller and started chewing it. So, good one. No, it's not yours. The last category I wanted to focus on was stepchildren. So stepchildren are interesting because how long someone's been a stepchild can be different. People can become stepchildren in adulthood when their parents form a relationship later on in life. So it's really different if you were raised in a blended family as stepchildren and you were raised by a step-parent. But stepchildren who are adults when their parents get together have a different standing. So most of these scenarios are exactly that. They're stepchildren who've not been raised by the step-parent. So the first case I've got was in the Supreme Court in 2016. It was the stepchild of a former relationship. So the argument was whether the person was even a stepchild still or not, so whether they were eligible. So this woman was 63 years old or so, I believe, when she made a claim against her stepfather's estate. So her mother had been the partner of the old man for 40 years. Her mother had died in 2001 and left her whole estate to him. He then formed a new relationship in the last 10 years of his life and left his whole estate to the new partner. He didn't have any children of his own. And so you can see it had been, 15 years since this woman, her mother had passed away. So was she still a stepchild? So yes, the court found that she was still a stepchild, and that she was eligible to make a claim. And so she was partially successful. Although the court did find that the new partner had good standing as well. So it's really difficult for someone in a blended family situation to weigh up their obligations to a new spouse and children from former relationships, or stepchildren from former relationships. But the main factor here was that her mother had stayed with the old guy all the way up until she passed away. So there wasn't a separation, and she'd left her entire estate to the old fella. So she didn't get anything when her mum died because there was an expectation that when the old fellow died, she would get something then. And then she didn't. Next one, in 2017, this estate was a little bit bigger. There was a house worth $1.2 million and cash of $155,000. So the old lady who passed away left her house to her 3 natural children. So the 1.2 million was divided between her own children, and then the residue of the estate was divided equally between her 3 children and the stepchild. So 155,000 divided 4 ways. So that's all the stepchild got. The stepchild was only getting $38,000 or so. So the stepchild made a claim. So the old woman had married the stepchild's father when the stepchild was 20 years old. So she was an adult when they got together, but the relationship had been 38 years. So it had been a long time. Then when the stepchild's father passed away, he left his whole estate to his wife, which is the stepmother, who's dead now. The stepdaughter, the lady we're following who made the claim, stayed with a relationship with her stepmother for a while, but then that relationship deteriorated. So then she gets written out of the will, essentially. So the stepdaughter's now 63 years old. Like I said, she only got about $38,000 under the will, and each of the natural children got about $450,000 each. The stepdaughter had not done all that well during her life. She owned a house with her husband. The house was only worth about $400,000, and she had super of about $100,000. And she and her husband were both on pensions in their early 60s. So done, no more earning income. She was awarded an extra $100,000. So that is what her relationship with her stepmother was worth, basically. So each of her natural children had to give up about, $35,000 each. So they still got over $400,000, and the stepdaughter got $138,000. Then legal fees would have come out of that too. So it would have been only about $100,000 in the end anyway. So not a great outcome for anyone. The last case I wanted to look at was a disabled stepson. So we're going to call this disabled stepson Billy. So this case was in Victoria in 2013. So Billy is 53 years old. He's illiterate, he's intellectually impaired, and he lives in a housing commission flat and gets a pension. So really small life, not much going on, simple man. Billy's father, don't know anything about his mum. So Billy's father married Billy's stepmom when Billy was 18. Billy's father then died in 2010, so only 3 years before this case, and left everything to the stepmom. After that, his stepmom redid the will, and the stepmom made a will that only left $100,000 to Billy in trust and left the balance of her estate to her brother and his wife. The estate ended up being about $450,000 in residue. So after Billy's $100,000. So $450,000 to stepmom's brother and wife. So she didn't have children of her own. She just didn't want it to go to Billy. So Billy makes a claim. He's awarded an extra $250,000. So he gets $350,000 in total, and the brother and his wife get $200,000. So I don't know if that's a horror story. I think that that's a really nice outcome. Billy doesn't have children though, so it'll be interesting to see what happens to Billy's money in the end. Oi. Now the dog's got a sock. Nope. So there you are. Those were all the cases that I wanted to go through in each of those categories. So you've got a fairly good understanding. I mean, I call this horror stories, but essentially a lot of these cases are almost justifying the purpose of legislation. And you can sort of see why some are awarded money and some aren't. So it all comes back to the estate planning. Quite a few of these cases weren't planned out very well in the first place. And so we make sure people actually deal with their estate plan and come out feeling like they're in control rather than overwhelmed when people are quite often really uncertain about what's going to happen. We take them through so that then they start getting proactive and they end up being certain and really have peace of mind. After going through our 5-step process. So 2 appointments. We get you some initial information when you ring up and book your first appointment. At the first appointment, we then do all the data collection, and we get to the point where we can draft documents for you. We make you a second appointment, and before you come into that, we send you draft documents so you can check them. If there's anything else we need to check, speak to financial planners or anything, we do that in between, so that by the second appointment, everything is ready for signing. Then after that, if there's anything tidying up, sending in binding nominations to super funds, getting powers of attorney to assign acceptance pages, all these bits and pieces, we finish that up, and then we deliver you the final plan with certified copies, and your originals all go into our safe custody as a free service. So if you would like to have a closer look at your estate plan, if you're worried about claims against your estate, usually we would do a review of your family situation for $450, a value of $800 because of what we can save you in the long run. However, if you mention that you watch this webinar, we will do your first appointment for $295. So you'll get your family situation review for only $295. So please call our office and book in, or you can visit that link on the screen. So take a screenshot of that. Otherwise, I wanted to say thank you. So that is our webinar for tonight. So I'm just going to have a quick look here in the chat. And it doesn't look like there's any specific questions here. So if you have any questions, or you're watching the replay, those questions get emailed to me. So I will regularly be checking and responding to questions that arise from this webinar. So I hope that that was useful for you. I hope that you have a great rest of the evening. I'm really sorry my dogs did not behave, but unfortunately that is life. So have a good evening. My name was Jacqui Brauman again, and I hope to hear from you and be able to help.